Investigate, evaluate, negotiate. That's the three-step maxim that adjusters have used for decades to handle claims. Today, we're here to talk about the second step in that process, evaluate. Specifically, we're going to talk about how to value personal injury claims. My name is Ben Peoples, and with me today is Judge Monty Ahalt. I'm a lawyer in the Washington, D.C. office of Thomas, and Hafer. Thomas, and Hafer is a regional civil defense firm with over 80 lawyers. In a few weeks, we'll open our 10th office in Virginia. Judge Ahalt is a retired judge from the Circuit Court for Prince George's County. Between when Judge Ahalt was in practice and when he was on the bench, he tried over 1,000 personal injury cases. Since he retired, he served as a private mediator and a court-appointed mediator, and he's mediated over 10,000 personal injury cases. Why I think that he's particularly well-suited for this presentation is because he has tracked the verdicts in personal injury cases in Prince George's County, Maryland, and Anne Arundel County, Maryland, for decades. For Prince George's County, dating back to the 90s. So he's intimately familiar with the value of claims and how they're valued in real life. Our presentation has three parts. First, we're going to discuss the components of value in a personal injury claim. Then we're going to talk about 12 methods that can be used to value personal injury claims. And then we're going to wrap this up by going over 3 hypothetical situations based on real-life scenarios and seeing what everybody thinks the value of those claims are. Before we begin, I would like to remind everybody, if you haven't already, to please go to the URL that was emailed around. This is an interactive presentation. The way you're going to interact is through that URL. During the presentation, you'll be asked a number of questions, and you'll have to respond, and your responses will come through the website on the URL. The second thing I'd like to say before we begin is thank you, Westminster American Insurance Company, for hosting us today in their beautiful facility. It is a stunning facility. For everybody on the webinar, if you haven't had the opportunity to come to Westminster American and you have the opportunity in the future, I would encourage you to do so. It is beautiful. So thank you, Westminster American. With that, we'll get started on the first portion of our presentation, where we'll talk about the 3 components of value, and I'll hand it off to Judge Ahalt.
Good afternoon, everybody. This is in a part one of my favorite times of the year, although it's cold. And it's one of my favorite times of the year because now that we've got all this football nonsense out of the way, we can really concentrate on something fun like college basketball. And just a little disclosure, I was born and raised in College Park, started attending Maryland basketball games at old Ritchie Coliseum on Route 1 when I was about 5 years old, and haven't missed a whole lot of games since then. And I played basketball competitively in high school and coached my kids. So I really enjoy the game of basketball, and I really enjoy the tremendous folks that are surrounded in basketball, the coaches, the reporters, the Feinsteins of the world, the Gary Williams of the world, the Lefty Drizzells of the world, the Dean Smiths. But of course, one of my favorites was, as everybody, was Jim Valvano. And I want to say that to you all because I want to pass on to you Jim Valvano's 4 secrets to success, because I think they can really apply to whatever you're doing in life at any time, including evaluating a case. My habit was to go to Cole Fieldhouse from my house in Mitchellville, Maryland, and on the way to the game, I'd listen to Johnny Holiday do his pre-game interviews, and we were playing North Carolina State, and he had Jim Valvano interviewing him, and he said, "Coach Valvano, you've been tremendously successful. What is your secret to success?" And Valvano says, "Well, it's easy, Johnny. All you have to do is you have to have a vision, you have to have a strategy, you have to be enthusiastic, and then you have to work your butt off." He says, "And if you do those 4 things in anything in life, you will be successful." Well, now Jim Valvano broke that down into basketball because that's what Holiday asked him. He says, "Well, how does that work out for your team in basketball?" And Valvano says, "Well, you have to have a vision. Obviously, my vision is to win the game. But my strategy," and this is where it really got interesting to me, "my strategy is to get to the last 2 minutes of the game, no more than 6 points down." I said to myself, "Well, that's stupid, Coach. Why wouldn't you want to be 6 points up rather than 6 points down?" Well, Valvano knew that being 6 points up all the time was going to be impossible, but if he could coach his kids not to get down too much, then his strategy was, I can convince these kids to play tremendous defense for the last 2 minutes because they'll have the stamina for just 2 minutes, and I can shut the other team out for the last 2 minutes, and then I'm going to have a stud who can score 8 points in the last 2 minutes. And then we all know how Vano was overly enthusiastic, especially when he won the national championship. So in evaluating claims, it's the same thing. You want to have a strategy of how you're going to successfully evaluate the claim, and you're going to have some enthusiasm as you do that. And then you're going to have to work like the devil to implement those. And if you do those things, you will be successful in evaluating the claim. Now, there are on the board components to value, and it's really all focused. Most people don't focus correctly, I believe, on how to start the process of evaluating. Now, I want to distinguish clearly about claims that have not entered the final process and are getting ready for suit, and those that are pre that position. Obviously, these principles don't apply to cases that are original claims, new claims, evolving claims, but the claims that haven't been settled and are ultimately going to go to court. So you want to focus on what's going to happen in the courthouse. And what's going to happen ultimately is the judge is going to design a jury sheet, and on that jury verdict sheet, he's going to have the questions which 6 jurors are going to have to answer. This up here has the liability questions, yes or no, and then the medical expenses and the lost wages and the non-economic damages. All of those questions can change depending on the case. But the point is, you want to focus on those questions when you evaluate the case. And the answer and the focus to the questions may be a little bit different. So every case, the liability is not clear. So there's a question on whether or not a plaintiff is going to achieve a yes or a defendant is going to achieve a no in this persuasion battle with the jury. And then when it comes to expenses, all medical expenses are not the same. And so there's a persuasion battle as to what medical expenses are caused by the accident, what medical expenses are reasonable, what medical expenses are probable, and the same with lost wages. The last item which all plaintiffs' lawyers want you to focus on is the non-economic damages. And non-economic damages have many different components depending on the other elements of the case.
So those are the first 3 components of valuing any claim, are liability, economic damages, and non-economic damages, and they're on every verdict sheet unless something's stipulated to that a jury gets. So let's go ahead and talk about the first of those components, judge liability, and tell them about this chart that's sort of based on your experience.
Well, this is just kind of a summary chart of potential different types of scenarios with an auto accident. You can expand that to a lot more scenarios than what I have up there, and you will get different percentages based upon experience for each. But it's easy if we just use a smaller number of scenarios to focus our thinking. So the first one is a rear-end accident case. There's no such thing as a perfect rear-end accident case, I say, unless it is so clear that the defendant's going to come into the courtroom and concede liability. In other words, tell the jury, we concede we're responsible for the happening of this accident, and you should check yes on the jury verdict sheet that you're going to get. Absent that, there's always a question as to whether or not the rear-ending individual acted unreasonable and negligent. Usually very small because of the law, so I put that at 90, 10 to 100%. A slip and fall where a defendant has actual notice, plaintiffs are unsuccessful in about a quarter of their cases. They're successful in 3/4 of their cases. In a red light, green light case, depending on the witnesses, you start evaluating at 50-50. If it's a clear light case and there's a witness saying the one light was red and the person ran through it, well then it moves out of the 50-50 to up closer to 100.
And these are all based on your experience over the past 5 decades of how these typical liability decisions come out at trial.
Correct.
And this is a good starting point when you're evaluating any liability cases. How does it match up with 50 years of experience on the chance of the plaintiff prevailing?
And remember, there isn't any exact answer. The exact answer in every case is what a party is successful in persuading all 6 of the jurors is the answer. So we're all trying to get inside the jurors' minds as to what is persuasive to them in order for them to ultimately come to the conclusion where they're going to check a responsible or not responsible in the liability section box. But you have to start evaluating at some point. And you may choose your experience may be different in any one of those, and that's okay. This is my experience, and it certainly isn't the end of the discussion. But the bigger point is you need a starting point in order to start evaluating the factors that exist in the unique facts of each case, whether it's going to plus the chances of the plaintiff up or plus the chances of the defendant up.
That's the first component of valuing a case, is liability. The second component is economic damages. For those who don't know, economic damages are things like medical expenses, lost wages, or loss of household services. We're not going to go over how to investigate those different types of damages in this presentation. That's for another time. But there are 2 things that I want to talk about. First, I want to alert everybody to a legal issue with regard to economic damages that comes up when you're handling claims in the Mid-Atlantic. The collateral source doctrine says that a party can recover their medical bills or lost wages even though they've been paid by another party, such as a health insurer. Maryland, D.C., and Virginia recognize the collateral source doctrine and allow that type of double dipping. Pennsylvania and New Jersey do not. So when you're evaluating economic damages, you have to keep in mind the collateral source doctrine depending on where you're located. The second thing I want to talk about with regard to economic damages is a question for the judge, and that is, are all economic damages created equal? Do you know what I mean by that?
They are, for sure. No, of course not. They are not created equal at all. There's some patterns, that's for sure, that we can discover with experience, and we can use those patterns in the same way we did with liability. We can use a pattern to start our analysis. we can use a pattern. We say, well, this happens more often than not, and let's look at our unique facts of this case and see if the pattern is a little bit different in one way or the other.
What are some of the types of economic damages that juries don't always award in full?
Well, let's just go to medical expenses. So I start out with the proposition that most all of the time jurors award medical expenses charged by medical providers. Think of it. Everybody on the jury goes through the similar process. When they go to a medical care provider, they don't get to negotiate the bill. The bill's sent to them. They have to pay the bill, whatever the bill is. So jurors pretty much follow that pattern. The differences come when the medical expenses aren't 100% arguably related to the accident. So the big example there would be physical therapy and pain management, treatment. So what we find is as physical therapy expenses increase or pain therapy increases, the likelihood of them all being awarded by the jury decreases.
What about medical bills for mental health treatment, Judge?
Well, mental health bills are a lot like physical therapy and pain management in that jurors generally recognize that somebody who needs counseling is going to go to counseling, and they're going to be helped by counseling. So it's not unusual in a good case where there's some traumatic event in the accident for psychiatric or psychological expenses to be awarded. But that usually stops the award. In other words, the award doesn't go then to extra pain and suffering because why did they go to the doctor? They went to the doctor to be relieved of their anxiety or their problem. The doctor provided their anxiety and leveled it, and now that ends their compensation.
Have you seen jurors treat claims for past lost wages and future lost wages differently, or do they treat those the same?
Generally speaking, future lost wages are difficult to persuade a jury to grant. Past lost wages are just pretty obvious.
Why is that, Judge?
The notion in most jurors' mind is that the future isn't certain. And so you're asking them to conclude, more likely so than not, or more probable than not, of some economic event 2, 3, 4, 5, 6 years down the road when everybody sitting there knows that nobody really knows what's going to happen.
Before we leave the second component of value, I want to talk about one other thing. Some plaintiffs' lawyers in the past 5 years have attempted to eliminate that second component of value, economic damages, by not introducing evidence of economic damages at trial. Their theory is that juries award the non-economic damages based on the amount of economic damages, and that juries tie their non-economic damages awards to the economic damages. So if they introduce evidence of low economic damages, they think the jury's only going to award low non-economic damages. If they don't introduce evidence of economic damages at all, their theory is the jury is not tied to anything or anchored to anything, and they'll award more in non-economic damages. That theory is called the reptile theory. We're not going to get into why it's called that today, but that's the background. And my question for the judge is, have you seen the reptile theory affect the value of cases at all in the past 5 or so years?
So first thing first, there is no real concrete definition of what a reptile theory is. You talk to 10 different lawyers, that are practicing and ask them to define what the reptile theory is and the reasons for it, you get 10 different answers. A lot of them are pretty much the same, but this is not like an idea that has some universal foundation adoption. But the general theory is that jurors can receive a message of value of the injury by the amount of expenses. That's the general theory. So if and that can work in strange ways. So I take the extreme example of a reptile case that I know about, where a fellow had his ankle really fractured and destroyed in an auto accident. He had an employment where he had to stand on his feet most of the time, and although he had a good recovery from the fracture, he had a lost motion and he had a lot of pain when he stood. The medical expenses were only $50,000. The plaintiff didn't put those medical expenses in, just put her client on the stand, had the family and work members testified as to his pain on a daily basis, $900,000 verdict. Now, everybody would agree that's an exceptionally high result, but that demonstrates the type of power that some cases can generate from excluding medical expenses from the jury's consideration. And there's this whole underlying fight that is going on in the courtroom as to how defendants deal with that. Do they put the medical expenses in? Can they put the medical expenses in? Do they object to them not being put in? And so all of that is kind of evolving. But generally speaking, what I'm seeing in my tracking is that about a third of the cases that are tried with the reptile theory, there is an extra value being awarded by jurors. It's not to the $900,000 case, but the typical $30,000 to $50,000 soft tissue case can easily turn into $70,000, $100,000 verdict.
Thanks, Judge. That's the second component of value in a personal injury claim is economic damages. We've talked about liability, we've talked about economic damages. Now we're going to talk about the third component, non-economic damages. The first thing I want to highlight for you is a legal issue with regard to non-economic damages in the higher exposure cases. Maryland has a cap on non-economic damages. The other jurisdictions in the Mid-Atlantic region do not. The cap changes every year, so you have to check a chart depending on when the date of loss is. So you may be wondering, what are non-economic damages? You're lucky in some sense because the law defines it. Each state has jury instructions that define what non-economic damages are, and they all vary slightly, but they generally have the same message. Non-economic damages are pain, suffering, annoyance, embarrassment, and disfigurement, that type of thing. Those words are easy to say, but what's difficult is placing a value on them. And that's what we're going to spend the rest of this portion of the presentation talking about, is the factors that affect the value of non-economic damages. Judge, when you see evidence, how do you categorize it with respect to non-economic damages?
Well, now, as the slide says, I characterize it into speaking and non-speaking evidence. But let me give you, my son's a lawyer in Greenbelt at McNamee Hosey. He's been practicing 25 years. And so when we did this article, I passed it on to him to edit and review and tell me what he thought, hoping he wouldn't think it was a whole bunch of junk. And he says, Dad, where did this speaking, non-speaking evidence come from? And I said, for a change, that's an Ahalt original. So the derivation of that is, back in the 2007, 2008, I had a case where the parties wanted to know in Southern Maryland what juries were doing and what were the components of $100,000 verdicts. And I went back and I looked at about 70 or so verdicts over 100,000 over a 10, 15-year period of time. And what I found just unequivocally so clear is all of those verdicts had at least 4 to 6 points of speaking evidence, what I call speaking evidence. So what's speaking evidence? Speaking evidence is evidence of something that no one needs to explain that it's really important. A crushed up car, jaws of life to get out of the car, a trip to shock trauma, a scar, where me as a lawyer, I don't have to do anything except show that to the jury, and the jury automatically knows this is really bad. So the converse of that is non-speaking evidence. That is, those points that require someone to explain and to advocate and to convince and to persuade of the importance, like a doctor's opinion as to causation of a pre-existing injury or the existence of a pre-existing injury or causation of work employment or not work employment. Those all require the lawyers in the case to get up and argue to the jury why they should adopt that position. And so it becomes a much greater barrier to success to someone who has to try and get all 6 jurors to reach that same thought process, whereas in the speaking evidence, all 6 jurors immediately see the crushed up car and they say, oh my God. It's to the point that I can say now after several cases that a trip to shock trauma on a helicopter is worth somewhere around $20,000 to $30,000 in extra pain and suffering element of a jury verdict. And if you stop to think about it, it's not too hard to reach that conclusion when you see that someone, the terror they're in as they go through that process.
And we're going to stop real quick and do the first interactive portion of this presentation. Go ahead and go to the URL, and the first survey question should be up. And the question is, what factors affect non-economic damages? And if you go ahead and type in a factor that affects non-economic damages, you're going to see it appear on the screen. If multiple people type in the same word, that word's going to get bigger. So we're going to see what factors the most people are typing in. Judge, venue is the biggest word that's being typed in, and I encourage people to continue typing in, but the most people are typing in venue. What's your view on the effect of venue on the value of a case?
Not as great as people think.
Why is that?
People are pretty much the same in the same geographic area. Now, when I say that, I'm talking about the preponderance of verdicts, not the exceptions. So there are big differences with the exceptional verdict. You know, the 1 or 2 out of 100, the jurisdictions that produce those exceptional verdicts do change. But let's just look for a moment at the 2 jurisdictions that I track jury verdicts in all the time. Dramatically different. Prince George's County, a large urban, almost Baltimore City now type of jurisdiction, 24 judges, some major low economic problems in the county, and Anne Arundel County, relatively small county, relatively high income, high demographics. When I first went to Anne Arundel County to start handling pretrials in the early 2000s, everybody was pretty much saying Anne Arundel County is at least 20, 30 20% below anywhere. They're very conservative. They aren't doing it. When I started tracking the cases, I said, that's not really what I'm seeing here at all. And so in the preponderance of cases, there is a difference, but the difference is really small. So if, let's say, 4 of us knowledgeable evaluators say the 80 out of 100 verdicts in this case will be between 80,000 and 100,000. The geographic difference is will be 100,000 more likely than so, not in Prince George's, and 80,000 in Anne Arundel. So there is a 20%, 10% difference in the value, but it's not a gross difference. And of course, the predominance of those verdicts anyway are somewhere in between 80 and 100. They're not on the edges of 80 and 100, so that even takes away less of the difference in the cases. I tell people regularly that you have to guard against the exceptions, though, when you're adjusting a case. So if you're adjusting a case in Prince George's County, the exceptions can be 18 million. In Anne Arundel County, they can be 400,000 or 500,000. So you would want to ordinarily maybe put a little bit more money on adjusting a Prince George's County case to protect your insured from that exception.
Judge, another word that's popped up here, and it's not a word, it's an acronym, I guess, ATTY, attorney. Does who the attorney is for either the defendant or the plaintiff make a difference?
Well, remember, this is the principle that starts the analysis. Bad facts and bad law cannot be changed by the greatest lawyer around. And good facts and good law can't be destroyed by the worst lawyer around. So a lot, it depends on the facts and the law of a case when you're looking at individual lawyers. But taking away the extremes, there's 1 or 2% of lawyers I call the great persuaders, who just have this ability, the Aristotle ability of pathos, logos, and ethos, to persuade 6 folks to come their ways. And it's no gray oration. They're just good elementary persuaders, and they do make a difference in a case. But it's a very small number.
Judge, we're going to move on, and you already talked about the difference between speaking and non-speaking evidence. Can you tell everybody about your metaphor for the effect of speaking and non-speaking evidence on the outcome of a case?
Well, I use this mainly in private mediations when we separate. And I use it mainly in plaintiffs' rooms where they have a lot of non-speaking evidence barriers to get over. I draw a horse racetrack and I put 2 X's for the 2 horses, and I tell them, okay, the horses have to stay in the same lane. Which one is going to win the race? And they most all say the one on the inside. And then I draw about 3 or 4 hedges in front of the one on the inside and tell them, okay, now that horse is going to have to jump over each one of those hedges. Which one of those horses is now going to win? And they all, most all, see the obvious and say, well, the one on the outside, because the one on the outside doesn't have to jump over any hedges. So the hedges are the non-speaking evidence points. So the more of those that you have, when you get 2 or 3 of those, I call those cases double trouble cases for plaintiffs. And their double trouble cases for plaintiffs are very rarely successful because they don't get the jurors on their side because they got to jump over those hedges and they keep falling behind.
Now we're coming to the second interactive portion of our presentation, and it's another survey question. The question is, what affects non-economic damages the most, or most to least, and you can rank them. So go ahead and begin ranking them. While you do, I have a question for the judge, how do you believe that jurors apply the definitions of non-economic damages?
They do it in a common sense, practical way that they see things happening in their own lives. Ultimately what happens in a jury trial is all the evidence is in, all the arguments are completed, and the jury goes back to the jury room, and 6 of them sit around the table and they start discussing value. And someone at one side of the table says, well, I think they should get $10,000 in non-economic damages. And someone at the other end of the table says, well, no, I think they should get $100,000. And then they start talking about that proposition, reaching a unanimous verdict like they have to. And as they're talking about that proposition and those numbers, they're relating to things that have happened in their own personal lives. And they see people overcoming great obstacles with pain and suffering every day in their own lives. So they don't always just jump to the conclusion that pain and suffering is such a terrible, life-changing event, because they see it in their lives with their grandparents, their kids, their parents, their colleagues. So it's most often just a comparison of everyday factors.
Judge, I'm going to look at the results of the poll so far, and people can keep voting, but it looks like some people are listening to you, and they have speaking evidence as the most important factor. The second one that's moved up to the top...
So my logos prevailed.
Exactly. But the second one that's moved up to the top, well, it was second, now it's third, is the plaintiff's likability. What do you think about that?
A plaintiff has to be likable. There's no question.
But does it have that much of an effect on non-economic damages as everybody thinks it does? Okay.
Well, it doesn't so much. It's more the plaintiff's unlikability than the likability. So I regularly sit in these private sessions, and I walk in the room and I sit down and I introduce myself and I tell the plaintiff, tell me what this injury has meant to you. And they sit there and very matter-of-factly tell me what the injury has meant to them and how it's interfered with the life and the troubles they have. And as they do that, what I'm doing is I'm sitting myself in the courtroom as if this person were in the courtroom, and I'm using my experience to say, how is that going to go across to a juror? And so I reach my own conclusion that this person is going to be seen very well by the jury, or ain't gonna believe a word this person says. And it isn't any different than if you sat in the room yourself, you would have the same reaction. And we might differ a little bit, but you would have a reaction as to whether the person's likable or unlikable.
But it's more the unlikability than likability.
It's more the unlikability.
Okay. We're going to move on to the next interactive portion of the presentation. The question for you is, how has the value of bodily injury claims changed at all in the last 5 years? While you're answering that question, I've got another question for the judge. One of the factors on the previous screen was experts. Do experts affect the value of the case in your experience?
No, they don't. Everybody thinks they do, but you have to kind of put it in context. And so let's throw the exceptions out of the window again. Can experts affect the jury to a conclusion? Absolutely, in a very small number of cases. Do they regularly affect the jury? No. And part of the big reason is, at the end of the case, the judge tells the jury what the law of expert witnesses are. And the judge tells the jury, ladies and gentlemen, you've heard from Dr. Jones testifying today. Dr. Jones came into court and gave an opinion. That's an exception to the general rule of any witness giving an opinion. Most witnesses can't give an opinion. But a person who has extra scientific or technical knowledge and education is allowed to come into court and give an opinion to help you decide the issues in this case. You should accept some portions of the expert's opinion as you find helpful and reject such portions as you don't find helpful. You may disregard all of the opinions of the experts and accept none of them, or you may accept all of them. And jurors kind of internalize. That's a complicated legal statement. They internalize that, and so okay, if the expert's helping them, it helps them. If it doesn't help them, it doesn't. And most of the time, it's kind of a neutral position.
So let's review the results of the most recent poll. The question was, has the value of personal injury claims decreased or increased or stayed the same over the past 5 years? And as you can see, 87% of the people, and there's about 120 people watching this presentation right now. I don't know that everybody's participating, but it'll give you an idea of the sample size. 87% of the people believe the value of personal injury claims has decreased. Only 10% believe it stayed the same. Well, I've got news for you.
Increased.
Yes, sorry. 87% believe it has increased. I've got news for you. The top executives at some of the nation's leading insurance companies agree with you. They've come out over the past year and observed and stated that they have observed an increase in the amount of money that they are paying in bodily injury claims over the past 3, 4, 5 years. And they credit it to inflation. And we're not just talking about economic inflation. Of course, there's going to be an increase in medical bills and lost wages because the cost of medical bill and the cost of labor is increasing. But they're also talking about social, what they call social inflation with respect to non-economic damages. They claim that as a society, we are valuing pain, suffering, disfigurement, embarrassment more than we were 5 years ago. What do they blame it on? They blame it on 5 things. They say there's a distrust of corporate America, there's income inequality, litigation funding is allowing more cases to go to suit and to go longer, and
who would you like to call?
nobody. And there is more ability to bring tort actions in the U.S. more than ever. And the last thing are the nuclear runaway jury verdicts. Those are the 5 things that the executives from Berkeley and Travelers and some of the commentators who have come out and said that the value of claims is increasing are blaming that increase on. So my point is, as we wrap up the first part of our presentation, the 3 components of value, my point is that the value of claims is not static. It changes over time. And right now, according to the industry and according to you, it's increasing. The second part of our presentation is the 12 methods for valuing personal injury claims. These are in no particular order, but I've grouped some of them together to help facilitate the conversation. The first group, well, actually, before we do that, let's do another poll. I forgot about this. What methods do you use to value personal injury claims? And you can choose more than one. Judge, in your experience, which of these methods, if any of them, is most prevalent?
I find that in the cases that are, 6 months out from a jury trial, that the most prevalent method of is the evaluative method. In other words, what does my experience tell me in this case a juror is going to do with the $20,000 medical expenses or the $15,000 lost wages or with whether the left-hand turning vehicle didn't see what was clearly there to be seen.
So it's experience?
So it's experience.
Now, let me ask you this. Does the popularity of a particular method change with regard to who it is? So do plaintiffs' lawyers use one method more than defense lawyers? Defense lawyers use one method more than plaintiffs' lawyers? Adjusters, do they use a method more or less? And same with mediators. Or is it basically all the same?
Things are changing. So 10 years ago, it was almost all evaluative for everybody.
All experience.
All experience. All experience based. If you go back 30 years, you go back maybe to Colossus, when Allstate was using Colossus all the time, and I used to fight with their adjusters. They said, I said, so how much are you offering in this case? And they said, $6,222.17. And I said, well, where does that number come from? Well, that's what Colossus says, and we ain't changing. So that was 30 years ago or more. And now we're in this stage with the reptile theory where there are a lot more unknowns. So our experience is evolving, and it has to catch up. So everybody's kind of looking around for something new to help them see what the answer is, rather than the age-old experience.
Let's talk about the first three methods, and I've grouped these together as the simple methods. The first one is valuing a claim based on 1/3 of the plaintiff's initial demand. The problem with this method is that you leave all the control in the hands of the plaintiff's lawyer. The adjusters, some experienced adjusters have told me anecdotally, and I've observed as well, is that it's actually pretty accurate. Claims often settle for 1/3 of what the initial demand is. I believe the reason why that is because the plaintiff's lawyers are being trained to demand 3 times what they know the value of the case is. But
changing. Now they're coming in and they're demanding policy limits at the beginning of the claims process, stays at policy limits even until they get into my mediation conference 6 weeks before trials, and doesn't change until a week before the jury trial.
So you may want to hesitate before you use that method moving forward, according to the judge.
Changing.
The second simple way is experience, and we've already talked about that. The problem with experience is, what if you don't have experience? And in this sense, I'm not just talking about years in the industry. I'm talking about experience with this particular type of case in this particular venue. At that point, you have to resort to some other method. The other thing I want to say about experience is it's not individual. It's collective. Just because a particular adjuster does not have experience with a claim, it doesn't mean that they can't handle it, as long as they are working with the other people in their office to put an accurate value on the claim. The third method that's simple is 2 or 3 times medical expenses, and a lot of people claim that this method is crude and it doesn't appreciate the nuances of each case. But there is some empirical evidence suggesting that it is accurate. In researching for this presentation, I found a 2016 article from the University of Chicago, a reputable source, that surveyed 1/3 of the personal injury jury verdicts in the United States and found that, on average, the jury awarded 2 times economic damages. So while it's a crude method, it might be accurate. All of these methods are simple, but there is a place for them, especially when an adjuster is handling a high volume of low exposure cases. We're going to go through 9 other methods, and you're going to see a lot of them require a lot of time and resources. If you're handling low exposure cases at a high volume, you don't have the time or money to engage in a lot of these other methods, and in that case, these methods can be very useful. These methods are also useful when you combine them with some of the other methods we're going to talk about. We've talked about this a little bit already. The fourth method is software, the most famous being Colossus, and the judge hinted about some of the problems with using this method. And the history behind the software, to me, illustrates some of those problems, and I thought you'd find it interesting. It originated in 1988 in Australia. Reportedly, the Australian Governmental Insurance Office was losing money and was looking for a way to change things up. So they hired a software company to create the software for them. Software company created it, and of course, the combined ratio turned around, and everybody attributed it to the software. Around the same time, Allstate was working with McKinsey & Company, the international consulting firm, and McKinsey recommended to Allstate that they use the Colossus, what came to be known as Colossus, software in the United States. Allstate used it, and all of a sudden their combine got better. USF&G followed suit, and by 2002, 12 of the top 20 insurers in the United States were using some form of evaluative software for claims. The plaintiffs' bar figured this out, and they spent the first decade in the 2000s attacking carriers that use the software. that attack culminated in a settlement in 2010 with Allstate, where Allstate paid $10 million based on allegations that they had failed to tune the software for the particular facts of each jurisdiction where they were handling claims. In other words, they didn't take into account the subjective issues that we all take into account every day when entering and programming the software to evaluate the claims. And that's sort of what the judge hinted at earlier. The fifth method I've called the Lloyd's method. And when I was getting ready for this presentation, I was telling my partner, Mike Burgoyne, about it. And Mike asked me, hey, what method does Judge Ahalt use? And I'd already spoken to Judge Ahalt. I know what he does. And I told Mike about it. And Mike says, oh, yeah, that's called the Lloyd's method. And I thought, I haven't heard that, but it's catchy. And it's a namesake of the London-based international insurance syndicate. So I went on Google, and I couldn't find anything calling this method the Lloyd's method. So I went on Lexis, and I did some research, and I couldn't find anything referring to the Lloyd's method. So I picked up the phone, I called the judge, and I said, Judge, have you ever heard your method referred to as the Lloyd's method? He said, no. So I can't find a shred of evidence that this method is actually called the Lloyd's method, but I figured I'd go with it because it's catchy.
Well, your partner said so it must be so.
Right. So at this point, Judge, tell everybody what your method is that we're calling the Lloyd's method.
I like the Ahalt method better. I mean, it has a much better ring to it. Well, it's a mathematical tool to take all of these factors that we have discussed and monetize risk. That's, we discuss all these little factors and they're affecting risk. Well, at the end of the day, they all have a monetary effect on a ultimate number, and so you have to monetize all of these factors in some fashion in order to get to a final dollars and cents evaluative position. But the simplest way to look at it is, okay, we've taken all of the evaluative factors into play, and we conclude that 80 out of 100 or 88 out of 10 cases will fall in between $80,000 and $100,000. So then you say, okay, that's the injury part of this process. How many chances out of 100 is the plaintiff going to be successful in achieving a verdict for the plaintiff? And so let's say you look at all of the factors over this change of lane situation as to notice and not notice, and whether they looked or could look or see or couldn't see. You've considered all those factors, and you say, well, I think under those circumstances the plaintiff is going to be successful 8 out of 10 times. So the monetization of your $80,000 to $100,000 risk is 80% of your $80,000 to $100,000.
So if you thought the case was worth $100,000, if liability was undisputed, and you think you got an 80% chance, the plaintiff has an 80% chance of prevailing on liability.
Settlement value is 80.
That's the Lloyd's method.
And it's a guide to the settlement process. It certainly isn't the end all to the process, because then you still use your negotiating and evaluative skills to finalize that monetary process. I will say one thing. After that evaluative process is done well by experienced evaluators, and the case goes to the trial, almost 90% of the verdicts are less, a tiny bit less than that number. So very few are higher than that number. So pretty accurately defines, in my mind, it defines risk for the defendant's side of the equation. and leads many insurance carriers when I go through that process and I say, okay, here's the reasons and here's my conclusion, and Sadie leads for the conclusion, well, we're going to stop at 78,000. And that's their risk factor. They feel comfortable with that risk factor, but they know more statistics than I know about what's happening on jury trials. The only bad part about that I see in some jurisdiction is you look out for the eagle.
Golf reference
in the verdict. I mean, what are you going to do when you get $200,000 outlier verdict and you put 78 on a case that really is 80 to 100? How are you going to explain that to the examiner?
So what you're saying is the problem with the Lloyd's method is that it doesn't account for the outlier verdicts.
Correct.
Okay.
It doesn't account on either side, really. It doesn't account for the outlier, except to the extent that you do that in your percentage of the results on liability or damages.
The next method is called the Belli method. Melvin Belli was a famous trial lawyer. Belli. I didn't even know who he was. I read about him.
Young guy.
The Belli method. Melvin Belli was a famous trial lawyer in the second half of the 20th century. In the 1950s, he published a handbook called Modern Trials. And in it, he included his method for valuing cases, and it was a points-based system. This is the way it worked. Every case could get a total of 100 points. Liability was worth 50 points, and then there are 5 other categories that are listed on the screen that are worth 1 to 10 points a piece. Belli would sit down and would grade each case based on that point system. So he would look at liability, and if liability was 50-50, he'd award 25 points. Then he would look at the injury, and if it was a fracture, he'd award 10. If it was a soft tissue injury, he'd award 1. Then you look at the age of the plaintiff, and I thought this was interesting. He put, if the plaintiff was young, he gave him a 10. If they were old, he gave him a 1. And so on and so forth. And he would come up with the total out of 100, and then he would place that as the numerator in a fraction. The denominator was 100. So you have a fraction of x over 100, and then he would multiply that by the best possible verdict. So what's the most the plaintiff could ever recover, and he would multiply that, and that's the settlement value according to Melvin Belli. Next method is the decision tree. The decision tree is a logical step-by-step approach where probabilities are assigned to each potential decision point that a jury or fact finder might encounter when rendering a verdict. You can start one of 2 ways. First, you can start by asking yourself who's going to prevail in liability, and then coming up with a probability. Or alternatively, you can ask how much is the maximum damages award. Regardless, once you get past those first 2 steps, you break the damages into 3 or 4 components depending on what the economic damages are. Here there were 4 components: medical bills, lost wages, household services, and non-economic damages. You then take the total amount of the best possible day and break it up between those 4 components. So X amount's medical bills, X amount is the maximum lost wages, X amount's maximum household services, X amount's maximum non-economic damages. For each of those categories, then you break it up into the potential ways a jury could decide. A jury could award all the medical bills, a jury could award none, a jury could award X in the middle. A jury could award this amount of lost wages, this amount of lost wages, or this amount of lost wages based on the expert testimony. You then assign a probability to each outcome. You multiply the probability times the total amount for that category, and that gives you a value that's in the right-hand column. You then add up all the values, and it gives you the settlement value at the bottom. This is time-consuming, and it's frustrating, and it's a pain. One thing I'll say about it, and I think it's true for all of these methods, or a lot of them, is that they're more analytical tools than magic wands. You're not supposed to go through this process and magically find what the answer is. They're tools to help you think about the facts of the case, apply them to the law, and evaluate. And this particular method makes you think about every fact. And that's the way I think it's effective. Not in that it gives you the value, because it involves the same type of subjective decision making, assigning the probabilities, as the other methods. The value in it is it makes you think about it. Judge, what is a neutral case evaluation?
It's something nobody ever uses
Why? Why?
because they're cheap. Is the bottom line, since I offer services as a neutral case evaluator. It's simply you coming to someone like me who has a lot of experience and saying, what, in your opinion, do you think a jury is going to do with this case? And give me the reasons why, the pluses and minuses of why that jury is going to do that case. It's never... I always say my knowledge is probably less than a seasoned insurance adjuster, because a seasoned long-term insurance adjuster is seeing a whole lot more than I'm seeing. I'm seeing a whole lot more focused on jury trials. But a seasoned adjuster or a group of seasoned adjusters who conference on a file, they are the experts in my job, in my notion. But it's especially helpful to individual plaintiffs who have no idea from the cost of a peanut to what a jury is going to do with their case. They have all sorts of expectations that are built by what they read in the newspaper, what their neighbor tells them, what the last person at the wedding said, all this anecdotal evidence, and then they have what their lawyer has said, and they don't have any real rational way of putting that into some concrete decision-making monetization of what a jury is likely to do so they can adjust risk.
So neutral case evaluations, if I'm hearing you correctly, are more a tool for the plaintiff side than the defense side.
Correct.
The next method is jury verdicts and settlement value research. The way this is done is you look back at other similar cases in the same venue and see what the total damages award was. There's databases on Lexis that you can use to do this. You then look at the report on the case and see how much economic damages were. You then evaluate how much the economic damages were multiplied by the jury to get to the total verdict, and that gives you the multiplier for the non-economic damages. Once you have a sufficient sample size of cases together, you figure out what the average multiplier is for that particular injury in that particular venue, and you multiply it times your economic damages in your case. Jury verdict research is criticized because plaintiffs report more verdicts than defendants, and they only report the good ones, so it's skewed. And of course, no two cases are alike. But it's another method to see whether your evaluation is lining up correctly. Next two methods are mock juries and shadow juries. Mock juries are presented with the evidence before a trial, and they report on how they feel about the evidence and the value of the case. Shadow juries watch the trial and report in real time as the case goes about the value. Obviously, these are tools that you use in larger, more high exposure cases. The last method is the calendar method. In this method, the evaluator assigns a dollar value to each day of treatment or disability that the plaintiff has experienced. So how much is it worth per day to have a sprained ankle? $100 per day, whatever you come up with, and then it's multiplied by the length of disability or the length of time they were under treatment. You then add that to the economic damages, and that's a settlement value. Of course, you have to factor in liability in some way, but this gives you what the settlement value is from a damages perspective. So those are the 12 methods, and that brings us to our next interactive question. And the question for you is to rank those methods. Which is the most effective? Judge, how do, while they're doing that, how do juries look at household services claims?
Like ordinary folks.
You keep saying that.
Well, that's what jurors are, ordinary folks. I mean, you can't sell something to somebody who knows in reality it is not practical. So when you get to evaluate and monetize household services, the numbers are always extremely large. And so a juror is sitting there saying, well, they're monetizing the household services at $100,000. Who spends that much for household services? Who has that much to spend? I'm only making $50,000. I'm doing all the same things that they're doing, and I'm doing it on a lot less than the $50,000 that I make. Why would I award them $100,000 for the household services? So plaintiff has a really high burden of persuading on the practicality of those numbers having been spent in the past by these individuals that have been injured to compensate them in the future.
So we've got about 35 results in now. The highest ranking method is experience. The second highest ranking method is multiplying by 2 or 3 times economic damages. The third is the Lloyd's method. The decision tree is very unpopular. It's at the bottom. Next to the Belli method, I wonder if that's a function of Belli being a plaintiff's lawyer and we're here with a bunch of defense people. I don't know. What do you think about these results, Judge?
It looks pretty common to me. I mean, that's pretty much what I see in the community of lawyers and adjusters evaluating claims. I mean, the number one is experience.
Is there a method that plaintiffs' lawyers use that we haven't talked about? We didn't prepare for this question, by the way.
That's going to depend on the firm. And all plaintiffs' firms are somewhat unique. And they will all have their little rules of how they are going to monetize risk and settle risk and try cases. Some firms are much more anxious and willing to try cases. They don't consider it any risk. They consider trying cases as a method of publicity almost, and if they work hard and fight hard for their client's satisfied no matter what the verdict is, and they'll spend the time and the money because it has a marketing component no matter what the verdict is. Other firms are more evaluative and more business approach to the actual numbers of the cases, and then you have the individual practitioners who are kind of just on their own and developing things on their own.
What do you think about the fact that the fourth ranked method on 11 up here is 1/3 of the plaintiff's or claimant's initial demand?
Well, I think that's because 125 of the 125 people that have responded are insurance representatives.
What do you mean by that?
Well, that is a common. I never hear that in plaintiff circles. In fact, I never heard it until we started discussing. I didn't even know it was a common practice in the insurance industry. What
did you say when I brought it up?
What?
What did you say when I brought it up?
I don't know. What did I say?
He said, you're right. That's about accurate. They usually do settle for about 1/3 of what the demand is. At this point, we're going to move on to the third portion of our presentation where we're going to review 3 hypotheticals and see how everybody values these cases. These hypotheticals are based on real-life situations, cases that I handled, so I'll be able to tell you what the case actually resolved for. The first case involves medical bills of $125,000 and a lien of $100,000. The injury was a fractured ankle and foot. The plaintiff's lawyer, he wasn't exceptional or unexceptional. He was neutral, and the venue was plaintiff-friendly. Judge, what do you think this case is worth?
350 to 425. Maybe 425 to 500. The lack of information on the employment is kind of an outlier. I'll tell you a little secret on broken ankles while everybody's doing this. So I was 39 years old when I was appointed as a judge in Prince George's County, and I thought I knew everything until I started sitting, and I knew nothing. But I was very fortunate. I had 3 wise judges who I went to lunch with every day, who really knew what they were doing. They were former State Farm lawyers, been on the bench for 10 years, Hartford lawyer, plaintiff lawyer. And so I had a broken ankle case, broken bone case one day, and I went to lunch and I said to the 3 wise men, after I told them what the medical expenses were, what's this case worth? And Judge Blackwell didn't even look up from his sandwich. He says, it's 5 times medicals, Monty. And I said, oh, get out of here. That's the stupidest thing I've ever heard, Your Honor. And he says, well, I don't care what you think. When I was trying him for State Farm, that's always what the verdicts were. And since I've been here in the Circuit Court for Prince George's County, that's always what the verdicts were. So you know what I started doing when I started tracking verdicts and recording verdicts. I'm going to prove Blackwell wrong. And I could never prove Blackwell wrong. So it's a pretty good rule, 5 times specials. Now you got to discount stuff out and put stuff in, obviously, but broken bone cases are considered by jurors as a real major pain and suffering event.
Well, this particular case was PG County, and it was a fracture, and it was a bad fracture. It settled for $450, which only 10% of the people picked that out. The couple of things about the case: the plaintiff was an elderly African-American gentleman. He actually fell asleep during his deposition. He was otherwise a nice guy. The reason why I didn't have any lost wages is because he'd been on disability for years. And I didn't have that high of an opinion about the value of the case until I deposed his treating physician. And his treating physician told me that it was the worst fracture he'd ever seen in his entire career. And he explained how the fracture happened. The guy's foot turned sideways when he was in the car and got rear-ended, and then it came back and it broke like that. And he as a treating, got some books off his shelf and showed me exactly how it happened. And that, in my mind, changed the value of this particular case. But only 10% of the people got it right. The next one.
So Blackwell was right.
Yes, yeah, it was close. It was close to Blackwell too.
Yeah. Blackwell was right. Again.
Yep.
Judge Blackwell, by the way, has been retired for any number of years. He's 95 years old, on to his second marriage, and he still thinks he knows everything. He does.
The next question is about a case where the medical bills were $190,000, the lost wages were $470,000, liability was admitted, the injury was a torn rotator cuff. Again, the plaintiff's lawyer was neutral, not exceptional, not unexceptional, and it was in a plaintiff-friendly jurisdiction. And the question is, what's this case worth? And I'm going to wait to ask the judge because he helped with this case. I don't know if he's going to remember it.
Yeah, I do remember it. The hard thing about this case is the $190,000 in medical bills. I mean, you see a lot of rotator cuff cases in injury, at least I do anyway. And the typical medical expenses for surgery on a rotator cuff is like $30,000 to $40,000, maybe exceptionally $50,000 or $60,000. So the medical bills kind of is a signal that something unusual is happening. Now, this could be something unusual that added to value or detracted from value.
And the unusual thing in this case was 3 surgeries. The doctors couldn't get it right. They went in one time, it didn't fix it. They went in another time, it didn't fix it. And in fact, the 3rd time didn't fix it either. The guy just didn't want to do a 4th surgery. He'd had enough, so he said he was going to live with it. So everybody
So I would be on the lower end of the scale.
What do you mean by that?
Here, I would be closer to 400 than 900. And I can't remember what we did, but I think the value is 500 to 600.
It was 625.
So
only 13% of the people reached that.
but I thought that was an exceptional result for a plaintiff for the reasons that I've just. But as I'm now thinking more about the case, I mean, he was genuine.
Yes, he was a very nice guy.
He was a genuine guy. It wasn't his fault that he had to have 3 surgeries. It was the accident caused all that to happen.
Well, and the judge didn't have an opportunity to meet our driver, who was not as impressive as the plaintiff. So that's the second hypothetical. The third hypothetical, the medical bills were $105,000. There was a $10,000 lien. There were no lost wages. Liability was admitted. There was a fractured pelvis, ribs, and torn rotator cuff. The plaintiff's lawyer was exceptional in this particular venue, and the venue was defense-friendly. I'll tell you a little bit about this case while you're voting. An elderly lady went to her friend's house for a Sunday dinner and walked out onto a deck, and while she was enjoying her Sunday dinner with her friends, it collapsed. The deck collapsed. She fell 15 to 20 feet to the ground, hit the ground, rolled down the hill, and the rest is history.
Blackwell says.
What's Blackwell say?
500,000.
Well, this isn't PG County.
This is.
This is not.
It doesn't,
Okay.
Blackwell's rule doesn't apply just to PG County.
All right.
So, I mean, at least that's what I'm finding. I mean, Blackwell's rule. Now, if you go to, let's say you go to Somerset County on the eastern shore and the lower neck of the eastern shore, well, the big factor that hurts this case is lost wages.
Well,
If there's a lost wage, if in a rural jurisdiction where there's a really significant lost wage cases, look out. The verdicts will be a lot bigger than you think
Why
could
is that?
happen. And because everybody's working and they use their body to work, and they realize that the body is so important economically that when that body is hurt, the economic value of the case is greater.
but that's particular to more blue-collar jurisdictions is what you're saying.
Yeah, in rural jurisdiction, farming community, where, you know, most of the communities are related somehow in the farming occupation, using their body to make an economic living. So you damage a part of the body that's interfering with that, they're going to award them more.
So the value of this case, or what it settled for, which everybody seemed to agree at the mediation, the plaintiff's lawyer, the defendant's lawyer, and the mediator, was $265. So everybody's a little high on that one.
They were influenced by Blackwell.
Investigate, evaluate, negotiate. We've talked about how to evaluate here today, specifically how to evaluate and value personal injury claims. We talked about the 3 components of damages: economic damages, non-economic damages, and liability. We reviewed 12 methods, and then we went through some hypotheticals to see how everybody's scored. I thank you for your time and attention. We run a little bit over, so we're not going to take questions right now. If anybody wants to chat afterwards, myself and the judge will be around. Feel free to come up and chat. Again, I'd like to thank Westminster American for hosting us, and have a good afternoon.